This video is to give an overview of how contracts are formed. So I'll be going through the essential elements of the formation of a contract. So what we will be learning in the next couple of videos is the specific elements that are needed in order for a contract to be deemed enforceable by law. Now I have a question for you. Suppose that I promise to excavate a given area for you in your project, and we both agree on a price. And let's say it was $450,000. We have, however, nothing in writing, so we've signed nothing. And the question is this promise enforceable by law? Is an oral promise, would it be enforceable? And the answer to this question is that yes, it will be enforceable. A lot of people would be surprised, but in the term contract, as you already know, it's about, a promise that is made between two parties. So the promise doesn't necessarily have to be in writing. It can be an oral promise, and it can be acceptance from the other side. And in that case, you'd have an oral contract form. So this is the situation that's created in this example that I gave: an oral contract, fully enforceable by law. It would be hard, however, I have to say. You'd have to go through a lot of struggles in order to prove that in the court. However, you could still enforce an oral contract. So it's always best to make sure that if you want to enter into a contract, that both parties have something written down. And that's what's explained over here. So just because there is no written contract doesn't mean that the court won't find that there is a contract. However, it's just that you will find it hard to establish the presence of a contract. Now, for a contract to be established, the court would look at several elements, and the elements are listed down in front of you. The first element is the offer, and there's requirements. There are principles that specify how the offer has to be made, what constitutes an offer, because sometimes you'd think that you're making an offer. However, that's not an offer but merely an invitation to treat. And an example of that would be if you auction your house, for instance. That's, you're not offering your house for sale, but you're inviting people um, to make offers to you. And then we have the second element, which is acceptance. How do you accept the offer? Under what circumstances do you accept? And how do you communicate that acceptance? So these are all aspects that the court would consider. The third element of a contract formation is consideration. There has to be sufficient consideration. It has to be real consideration that's given. And consideration basically refers to the price that's paid by the promisee to the promisor. So the promisor is the person making the promise, and then the promisee is the person who then need to pay a price in return for that promise. The fourth aspect, or the fourth element necessary for establishing a contract, is that there has to be an intention to be legally bound by both parties. And this is a very important aspect. So without the intention, even if both parties had signed contracts, if the intention was lacking to be legally bound, then the court would find that the contract is non-enforceable. So there was no contract to be enforced. Final element that the court would consider is capacity. So are the individuals, do they have the capacity to enter the contract? Are they, above a certain age? Do they understand the consequences of their actions? So this is a list of all the necessary elements that the court would have to go through to make sure that a contract is established between two parties.